Hi there, I'm Matthew Lester from the Rhodes Business School. Now, the moment that you get into tax, people start talking about anti-avoidance, tax evasion, and a whole lot more. And those that get really enthusiastic about tax, the real nerds, they then go and write thesis after thesis about the general anti-avoidance regulations of the Income Tax Act. And they've had a lot to talk about over the last few years because it's been overhauled both in the legislation, as you can see in the board there, or in terms of the interpretation of the legislation by our courts. And so one has to find a happy medium to when you're in the right and when you're in the wrong. And even that has changed. 20 years ago, tax advisors were the belle of the ball. Everybody got them in to devise all sorts of funny structures all over the world to bring them into the field of aggressive tax planning. Today, a board will consider it a little bit differently. They say they have a higher social responsibility, that they must pay their taxes, they don't want to land up in controversy, and a whole lot more. So we have this very difficult question of finding out where a company actually exists with regard to its tax planning. So let's try and explain it like this. This is another morality spectrum. So we put up two lines and we say, if you never register for tax, you will go to jail. On the other extreme, if you never claim a tax deduction, you will go insolvent. Those are two pretty wide dimensions. Now we have to find out where we live on those dimensions. Now let's take some characters. Let's take Aristotle Onassis from the 1970s. He said there are no rules. Well, he'd be in jail today. Then there are those who are always playing the moral high ground. Let's put Trevor Manuel there and say he'd never claim a tax deduction, would he? Well, we can't go to that extreme or we're going to drive our businesses insolvent. We need to see how those two forces progress against each other. Now, there are different levels when one looks at anti-avoidance that can fill in across the spectrum. An MBA student doesn't need to know them in a whole lot of detail. If you were doing a higher diploma in tax law, maybe you do need to know them in more detail. The important thing in practice, though, is that if you get into one of these disputes, you are looking at multi-millions just in the legal fees. And that's why a lot of people today are trying to avoid getting into trouble with SARS, and they would rather pay their taxes. So let's look at it and say, go back many, many years to the famous cases that say you're allowed to plan your taxes. So there's old Lord President Clyde in Esher Pullman Motors, that's nearly 100 years ago, when he said that His Majesty's subjects are free to make their own arrangements to make sure that their affairs fall outside the taxing acts. They incur no penalties and, strictly speaking, no moral censure if, after looking at the law imposed by the legislator, they make it their business to walk outside them. Now, that's 100 years ago. If you think that's going to work today, I wouldn't go out there. You have to be a lot more careful about it. So let's go about it in a different line, go to the tax morality spectrum again, and we're going to start off with a particular type of transaction. And that's called an infraudum leges transaction. Now, tax has a lot of Latin in it. We have to explain what on earth they're meaning about it. And again, we go back over 100 years to Zandberg versus Van Zyl, and Judge Watermeyer, as he then was, he became a legend in South African tax. And he said the following about a transaction. He says, the parties to a transaction endeavor to conceal its real character. They call it by a name or give it a shape, intended not to express, but rather to disguise its true nature. And he continues. He says, when a court is asked to decide on the rights under such agreements, it will give effect to what the transaction really is and not what it purports to be. Then comes the big Latin maxim. He says, the maxim then applies plus vale quod agitur quam quod simulate concipita. A very literal translation of that is bullshitters will not be tolerated. We will look at a transaction and delve into the mind of the people to that transaction and say, what were they thinking? And we'll interpret along those lines. The great tax academic Pierre du Toit once described this as Bloemfontein blush. You go to the Supreme Court of Appeals in Bloemfontein and they ask you, was this what you really intended? And if you blush, then they're going to interpret it as something else. Right, now this was taken further recently in a controversial case called CSARS versus NWK. Many tax commentators are saying the judge has lost her mind. She says that the test should go further and require an examination of the commercial sense of a transaction or of its real substance and form. She says that if the purpose of a transaction is only to achieve an object that allows the evasion of tax, then it will be regarded automatically as simulated. And the mere fact that the parties do actually perform in accordance with the contract does not necessarily mean that the transaction is not simulated. So, the charade of performance, says Lewis, is generally meant to give credence to their simulation, and we must look through that. She says, in my view, the test to determine simulation cannot simply be whether there is an intention to contract in a particular way. And where the parties structure a transaction, then they will give effect to what they actually intended. If the purpose of a transaction, says Lewis, is an object that allows for the evasion of tax, then it will be automatically regarded as a simulation. Now, this judgment has been through the mill in interpretation. Many people say we should just simply disregard it. Other people say it has changed the parameters of tax planning, as it pushed the whole question of what is an infraudiblegious transaction into a far more serious league, where it is far easier for SARS to succeed by simply stamping on a transaction saying it was designed for the evasion of tax. This then brings in the debate about what is substance over form. And again, going back nearly 100 years ago, we look at how courts have interpreted this issue of substance over form. And Lord Tomlin, in Inland Revenue Commissioners versus Westminster, had no time for the doctrine of substance over form. He said, let's have a look at this and what should we actually be saying about it. He's saying, the sooner this doctrine is given its quietus, in other words, shut up, the better it will be for all, as the doctrine is no more than substituting the uncertain cord of discretion for the golden and straight meter wand of the law. So what Tomlin is actually saying is that the revenue authorities have the ability to write the act. If their act falls short, well, then they mustn't complain. They must apply the law as it stands and not make it up as they go along. Well, let's see where that goes. So we're saying, no, we haven't gone as far as substance over form, but there have been other developments. When one looks at the SCA decision in NWK, we've got to say, does it change life? And some say maybe, some say not. It will depend on the facts in each case. Is the SCA allowed to just make up its mind in judgments? Well, one always has to say that the SCA will favour SARS in a tax matter. They say that's their job to do that. But we don't know what the real outcome is going to be, and we don't in fact know whether it changes much. Because this might all be academic. What has happened in the meantime is that they have rewritten the General Anti-Avoidance Regulations in the Income Tax Act, or Gaar as we call it, in the new Section 80 to the Income Tax Act. And with that there, you probably wouldn't capitulate long before you went and contested the matter before the Supreme Court of Appeals. Now that's what's more relevant. So what we are saying is that there are new provisions within the Income Tax Act under Section 80. These are very extensive provisions. The legislation goes on from pages and pages and pages in various long subsections that you can write a thesis about every one of them if you want to. The important issue in the context of an MBA is to have a bare outline of what Section 80 is all about. Then your duty as a director is to say, I am looking at a tax matter. I am aware that Section 80 exists. And unless I can get a concrete opinion, I'm going to be worried. So we take our transactions and we say, unless we are absolutely certain of the tax consequences, the Companies Act is telling us to go and get a professional opinion. But to get a professional opinion, you have to basically be able to say, I understand more or less what we are talking about. So let's go into it very briefly. And we start off with the basic charging provision in Section 80A. Section 80A identifies an impermissible arrangement. It says in Section 81 that a transaction will be an impermissible avoidance arrangement if, having looked at the way that the transaction is carried out, it is carried out for a non-bona fide business purpose and with no other purpose but to obtain a tax benefit. And then in item 2, it says the transaction lacks commercial substance, and for that, go and have a look at the definitions in Section 80C. The provisions then continue in item B, where it looks at non-business transactions. It says they will be non-permissible arrangements if they lack a bona fide purpose and were put in there for an objective solely to obtain a tax advantage. And then in item C, they are saying a transaction can also be an impermissible arrangement where it has been entered into in a manner which is not at arm's length, or is there simply to frustrate the purposes of the Act. So what we are looking in Section 80A at is an overall introduction to an impermissible arrangement. And they're saying, if you're out there to simply get around the tax system in a non-bona fide business manner, you will trip off Section 80A. 80A is then followed by the consequences, which are put there in 80B. And 80B says, where we have an impermissible arrangement in terms of Section 80A, then 80B can be activated, and then SARS is allowed to bypass the arrangement. And SARS is then given a whole range of alternatives as to what they can do to recover the tax. They can either combine income with other people, disregard accommodating or tax-free parties. They can then go and look at reallocating income. They can do a whole range of things to minimize the arrangement. They can treat the arrangement as if it was not entered into, or they can reclassify income from being revenue or capital in nature. Subsection 2 is probably the most appropriate and most often used by SARS, where they say in terms of 80B, if 80A is activated, the Commissioner may make compensating adjustments that are necessary to ensure the consistent treatment of all parties to an impermissible tax arrangement. So what have we said so far is that we've got 80A, which is an impermissible arrangement, and 80B, which says SARS can then correct the matter. We then follow on to further provisions, which are those dealing with commercial substance. You remember in Section 80A, we talked about an impermissible arrangement being a transaction that lacks commercial substance, and for that, please go and look in Section 80C. So there's Section 80C, which defines when a transaction lacks commercial substance, and basically it looks at the transaction and says, is this a genuine business transaction? For that, it can look at the commercial risks. It can also look at the beneficial ownership of assets and say, are these genuine in the course of business? They can also look at the economic effect and say, is that inconsistent from the legal form or the individual steps making up the transaction. They can also say 80C is then expanded. It says, go and look at section 80D. And 80D will have provisions relating to round-trip financing, and then go and have a look at section 80E, which has provisions relating to tax accommodating parties and how those transactions can cancel each other out. So you have A as an impermissible arrangement, B is the consequence of an impermissible arrangement, C is the question of commercial substance which can trigger off item A. C is then expanded through D, which looks at round-trip financing. Now, what is round-trip financing? Round-trip financing is where a transaction lands up with money going away from a taxpayer, going on a trip, and landing back in the same taxpayer's hands in the same format but not taxable. So effectively, I'm giving my income to somebody else to pay tax on it or not pay tax on it, and they're giving it back to me as tax-free money. If you do that, then you trigger section 80D, which triggers 80C, which triggers 80A. Then we continue it and we say D is round-trip financing, E is a tax accommodating party. Now, a tax accommodating party is essentially a tax-free party. That can be a company that has a massive tax loss, or it can be an offshore company. These companies pay taxes at lower rates than the taxpayer themselves. So what they're saying is, redirect income in favor of a taxpayer with a low tax rate and send it back to me in a different form. If you do that, then the party that is helping you is a tax accommodating party, and their involvement with the tax accommodating party is then disregarded in terms of the consequences in section 80B. Then the final big provision that we're going to look at in this video is the question of connected persons. Connected persons is a term in tax which basically relates to your relatives and your companies that you may hold. So we have a whole extensive definition of connected persons in the Income Tax Act, all your relatives, all your trusts, all the companies that you may own. In one way or another, you're probably a connected person to half the yellow pages. But if you do a transaction with a connected person, and it is not at arm's length, then section 80F comes into operation to trigger off section 80A. So you'd have an impermissible arrangement involving a connected person identified in section 80F, which would give to an adjustment in terms of section 80B. So there are all the major provisions of section 80 that a director has to know about. There are a lot of other administrative provisions within section 80. I'll talk about them briefly. The presumption of purpose test is basically put on the taxpayer. You are presumed to be fooling around until you can prove otherwise. Always watch that in tax. You're guilty until proven innocent. So it's not for SARS to prove something. They've merely got to make an allegation that you are up to something. Then the problem starts from there. Next is application of steps. Taxpayers often argue that they have various commercial reasons overall for entering into a transaction. What section 80H allows SARS to do is to look at one step in a series of transactions and hone in on that and say, does that one step contravene section 80? If it contravenes section 80, then the entire arrangement would then fall within impermissible arrangements under 80A, leading to the consequences in terms of section 80B. Use in the alternative. Now, this is a provision that didn't used to be there. What they used to say is if SARS reverts to the general anti-avoidance regulations, that means that no other provision in the Tax Act can apply in those circumstances. That's now overridden in section 80I. SARS can use section 80 in the alternative to any other provision in the Tax Act. 80J is an important provision. SARS can't simply pitch up with an assessment applying the 80B consequences. If SARS is going to bring up an impermissible arrangement allegation in terms of Section 80A, they have to give a notice to the taxpayer in terms of 80J to say, we have observed this, we say it's an impermissible arrangement, and we are giving you notice that we are going to apply Section 80B. The taxpayer is then given a period to respond before the actual assessment is raised. It's very important that you do this, because if you don't, you can be presumed to have accepted what SARS is doing. So very important is that if any company ever receives a document where Section 80 is stated, then you must respond to SARS prior to the assessment being raised. 80K has good news and bad news. If you have an impermissible arrangement taxed in terms of Section 80, SARS is entitled to raise interest on the underpayment of tax. In contrast, SARS is not allowed to raise a penalty if they apply Section 80. Now, if we look at other provisions of the Tax Act that can be applied, they lead to penalties and interest charges. So sometimes it's actually better to be taxed in terms of Section 80 rather than other provisions within the Tax Act. And then finally, we have all the definitions contained in 80L. What does all of this say? Well, in the old days, we used to see a tremendous number of these cases actually making it to the courts and being interpreted. That's not happening today. People are saying that Section 80 is so strong that it's not worth litigating. Many taxpayers that get caught up in Section 80 run for alternative dispute resolution with SARS in order to negate the full effects of Section 80B and come to an agreed assessment. That is another reason why it is important to look at when you get notice of a pending 80A application. The important thing is to take professional advice and respond to SARS in writing as to what you're doing. Be part of the process rather than letting SARS come to its own conclusions. Then you must consider as a director, do you even want to play in this game? Aggressive tax planning today has enormous costs, not only in the form of interest and the legal fees that can be imposed, but also on a company's reputation. The press just love a case involving impermissible tax arrangements, and that brings the company's tax affairs into the public eye, and that can affect the reputation of your company. So before you take that line, every taxpayer is due his day in court. One must consider not only the taxes and interest charges and legal fees if you lose, but also the reputational risk of a company that wants to incur the wrath of SARS. I'm Matthew Lester at the Rhodes Business School. Thank you for your attention.